you paying off things as I am you having continued contact with her.
I'm not gonna be in contact with her anymore.
Is there a way, Judge, to put them on a GPS and reset this for 60 days?
No, I'm going to make my decision today because I'm absolutely, if I leave him on probation, he's going to safety, period. So we're not going to get out and see how we do and take that chance without having some kind of treatment up front. I don't know. Y'all hold on a second. Just don't take them far. For some reason, Anna, when I pull up the version that should have my notes on it, it doesn't have anything on it. So I don't know if I didn't save it. You know, I have the prior version and the the new version. I've printed out that new version and it doesn't have it. The date and all that. So I might need to go back and handwrite something from that date, but just remind me I put a sticky on this. Okay, let's see. Ms. Holmes on Samuel Harmon.
Yes, sir. Samuel Harmon. So, side note on him. His dad called me and said he filed a grievance on me, but I'm still gonna represent him. But he apologized for filing it because he said he didn't know I was coming to visit him that day. Yeah.
The joys of what you do.
Yeah.
Good morning. Are you Samuel Harmon?
Yes, ma'am.
And this is 25 DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And Ms. Holmes, what is the announcement?
Yes, Sharon, if we could get one more reset. We did receive another offer from the state today that I would like Mr. Harmon to review with his family. And also I'll come out to visit with him as well so we can make a decision by the
All
next
right.
work.
I'll reset one more time. Any issues?
Just, Your Honor, that was a 12-year offer that is going to remain open until the next court setting.
Okay.
Withdrawn.
Okay, so Mr. Harmon, it sounds like there's an offer that's on the table that they've going to keep open until that next court date. Make sure you visit with Ms. Holmes about it, visit with your family about it. Sounds like there's not any more negotiation. The offer is what it is. If you want to take it, we'll take care of that when you come back. If you don't, you want to trial, we'll get your case set for trial. Okay, you can go back with the bailiff.
Thank you, Your Honor.
Brittany Litchfield,
Yes.
would y'all, I'll print the first one if you'll print the second one, please. Is Burbank still in here?
Yes.
Mr. Burbank, do you have somewhere else to be?
No.
Okay, I'm just gonna give me just a minute to
Yeah,
do.
no, I was supposed to be in hard county. I'm not going back.
Okay, okay,
Take all that. I'm here.
okay, thank you. Good morning, are you Brittany Litchfield? Give me just a second to get this printed out. And will your client waive the formal reading of the motion in each case?
Yes, Your Honor.
Ms. Litchfield, in cause number 21-37098, I have a motion to revoke your community supervision. Shows that you were placed on probation December 12th of 2022 for the state jail felony offense of abandoning a child, and that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Judge will still abandon, I guess it's 6 and 7 on each motion and just proceed on 1 through 5.
In each motion, 1 through 5?
Yes, ma'am.
It's okay. All right, and then in cause number 21-37099, I also have a motion to revoke your community supervision. Shows you were again placed on probation December 12th of 2022 for the offense of abandoning a child, and that was also a 2-year term in state jail prison that was probated for 5 years. Is that also correct? Each of these cases, the state has elected to proceed on counts 1 through 5 in the motions. They each allege in count 1 that you violated your probation by failing to report to the probation department as directed October 15th, October 31st, and November 14th of 2024. And is that true or not true? Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 3 in each case alleges that you failed to immediately report to the probation officer your current address. Is that true or not true? Count 4 alleges that you failed to provide verification of performing the community service hours that were required. Is that true or not true? And then count 5 alleges that you failed to provide verification of entering and successfully completing the parenting class. And is that true or not true? Did you enter your pleas of true to counts 1 through 5 freely and voluntarily? Yes, ma'am. And did you plead true to those counts in each case because they're actually true? In each of your cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Litchfield is not
No,
competent?
Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probation. In cause number 21-37098, revoke your probation and reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25-37099, also find sufficient evidence to revoke your probation, and at this time revoke your probation, reassess your punishment in accordance with that agreement to a term of 12 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each case the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am, and thank you for being here.
On bail. There is one in there
There
that
is.
says revised, yes. You must have not saved it, or
I must have
didn't
not.
save it, and then I must have printed and
Got
gave
it.
it to you.
Okay.
So there is. Do you need it?
I can, yeah. Yes. Maya Sparks, Ms. Holmes.
I'm not gonna say yes to yeah, just for the mental stuff too. I don't know.
persons.
Probably not. But now I get to speak.
Good morning. Are you Maya Sparks? And will your client waive the formal reading of the indictment in each case?
Yes, sir.
Ms. Sparks, in cause number 25, DCCR 0145, you're charged with the third-degree felony offense of assault on a public servant from October 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? Speak up, please. And then in cause number 25 DCCR 0146, you're also charged with a third-degree felony offense of assault on a public servant from October 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand? And it looks like the agreement that you've reached in each of your cases is for a 6-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Sparks is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we will come back at a later date for sentencing. Mr. Nichols, what is the state's position on bond?
Judge, I'm a little concerned about a PSI bond because of the way these cases occurred. There might be an issue that I do anticipate you at the very least being placed on mental health caseload. I don't think it's a competency issue. I've discussed with Ms. Holmes. But I don't know if the court's going to decide that either an ISF or safety program is in the best interest here.
Okay.
The facts in this case involve threatening staff at a school. So it gives me a little bit extra concern. And there was one jail incident in the last week that gave me a little concern as well.
Okay.
Yes, Your Honor. So Ms. Sparks and I've spoken with her mother. Her mother is here. On this particular incident, there was a episode. She had a mental episode where she was not on medication at that time. She is compliant on medication now.
Okay.
And we are asking, her mother is taking care of her child. Her child was attending that school that she went to. And so I do feel that if she stays on her medication and stays compliant, that she will be okay. And so we were asking if the court would consider a PSI bond.
I guess the concern is without the probation order where, has she been to Spinal Top before have you gone through Spinal Top before? You are a Spinal Top patient?
She's diagnosed bipolar and major depressive disorder.
Okay. So what I'm going to do, Ms. Sparks, just kind of based on also time of the year, I'm gonna reduce the bond, but I'm gonna have some very specific conditions on that bond. And you're gonna have to follow those conditions exactly. If you don't, because you're gonna have to give Ms. Holmes proof that you're doing some things that I'm gonna order you to do. And if you're not doing those things, then I'll issue a warrant for your arrest. We'll get you back in custody until that pre-sentence report's done, and then we know what everything is that you could potentially need. Was there also any type of, or is there any kind of drug issue, or is it primarily mental
It was
health?
just mental.
Okay, so Ms. Sparks, I'm going to reduce your bond in each of your cases to $2,500. If you make those bonds, the conditions of the bonds are that you immediately have an appointment, make an appointment with Spindletop, that you give proof of when that appointment is to Ms. Holmes. So I'm saying the day you get out, you make the phone call, you set an appointment, and Ms. Holmes needs to know when that appointment is. You don't wait a week to set the appointment or 2 weeks or anything like that. You set it the day you get out of jail if you make the bonds. Does that make sense? In addition, I am ordering that you remain on your medication. So now it's not just whether you want to or you feel like you need to, it's a court order. And if you don't do it, you're back in custody. Do you understand? So is her mother okay with her living with her? Where's mom? Thank you, ma'am. And thank you for being here. So I'm going to order that you remain living at your mother's house. You can't go spend the night anywhere else. You can't go anywhere else. You stay there. You go to Spindletop. You get yourself back on track so you can be fine and do this probation and not have any issues. Does that make sense? You are not to go to any of the schools wherever your child or children are going to school. You are not allowed to go there, period. Do you understand? Okay. That's not until I order otherwise. So for now, you cannot go to any school that they are attending. Okay? If somebody needs to pick up and drop off, that's going to be her or someone else. If there's a school program between now and when you come back, I don't care. You don't get to go. Do you understand how serious I am about that? Okay. Any other conditions that you feel
I
like?
think that will cover it, Your Honor.
Okay. All right. We'll see you back at sentencing. You can go back with the bailiff. Okay, I'm writing it all on my docket,
Here, I was gonna say,
so I'll write it again.
you don't have to.
Here, just keep it to the side and I'll do it. Remind me. But I did write it all down.
Okay, thanks.
I redid the paperwork on my judge.
Okay, thank you. Mr. Kimler, what is the announcement on Jeremiah Branch?
I don't know, we're getting sworn.
Okay, I'll hold it and take care of those when they're ready. Mr. Lewis, I was holding Russell Bean.
Judge, that one, I've gone next door to check to see what Mr. Cole got.
Oh, okay.
But he hasn't, he hasn't.
We're
got it
waiting
yet.
on that. I need to make that note. Okay. What about Denzel Spikes?
Yeah, that was a complete.
Okay, I'll take care of that when it comes through. Let's see, on Cecilia Delaney, did y'all get her? Yes. Let's take care of Miss Delaney, Mr. Parker.
Forgot about that one.
And this is one where they say outpatient, but I don't have,
Do you think she needs to go for longer than the 120 days?
well, it'll be a civil commitment today for a year. So that's why we had to bring her back, because that was just for the 120. And so now I can do the civil commitment for the 1 year. And even though it's recommending outpatient, I'll make it inpatient so that, because we don't have an outpatient.
All the way down number 78 of the list of what we've done.
For you?
I
need
don't-
one.
I'll go for a while. Yeah, why not? Is it a state jail felony? Or is it a third? We also need to watch out for,
Statute.
okay, yeah.
Because it doesn't look as if it's a public danger.
Right.
Thought we just did some September.
This is one we were trying to get earlier.
Yeah. Oh, that thing.
No, why they have this journal? It's too big.
Sharon would have done it first try.
All right, this is cause number 24, DCCR 1386, and are you Cecilia Delaney? And Ms. Delaney is in court, was previously found not competent to stand trial, was transferred to the John Dunn Behavioral Science Center for competency restoration for a period of not to exceed 120 days. I have received the report from them, and we'll take judicial notice of the court's file, including that report. Included in that is the trial competency evaluation report, which was prepared by Dr. Mary Ann Robinson. The opinion in that report is that Ms. Delaney is still not competent to stand trial, and that further treatment would be required for competency restoration. In addition, there is a forensic psychiatry report that was prepared and by a Dr. Selleck, S-E-L-E-K. Again, the finding it with him is that she is not competent to stand trial. Additionally, we have a physician certificate of medical examination for mental illness from Dr. Selleck. The finding in that is that Ms. Delaney does not meet the criteria for inpatient commitment, but meets all of the criteria for an outpatient commitment, with the specific findings that the nature of the mental illness is severe and persistent. As a result of it, if not treated, that she would experience deterioration and the ability to function independently. And in addition, we have a second physician certificate of medical examination for mental illness from a Dr. Lee. The finding is the same in that Ms. Delaney meets the requirement for outpatient commitment based on the nature of her mental illness being severe and persistent, and that if not treated will experience deterioration and the ability to function independently. That's it. It's another one. Okay, so that being said, well, is there any other evidence with regard to competency?
No, Your Honor.
So obviously, you guys both know we do not have an outpatient treatment facility in Jefferson County.
Right.
We don't have a jail competency restoration or outpatient competency restoration. So that being said, I have no choice at this point but to find that Ms. Delaney is still not competent to stand trial, and find that commitment inpatient would be required because we do not have outpatient commitment facility, because the nature of her mental illness is severe and persistent, and that if not treated, she would not be able to function independently and live safely in the community without the court-ordered treatment services. And so I am going to order a civil commitment for a period of not to exceed 1 year for competency restoration at the appropriate facility. If there is restoration prior to that, they'll let us know and we'll get Ms. Delaney back. Otherwise, we will wait for their report and have a hearing at that time. Ms. Delaney can go back. Ms. Perazzo, are you ready on Trevon Alexander?